Present in the virtual courtroom, we have both parties along with attorney Nancy Ballast representing the defendant. We are here on the defendant's motion to enter the judgment, or I'm sorry, the plaintiff's motion to enter the judgment of divorce, a proposed judgment. Ms. Ballast.
I wanted to make a slight correction to my pleadings. The first allegation says that there was a settlement placed on the record. That's not exactly accurate. There was actually a trial in this matter. The parties were ordered to do certain things as a result of that trial. I prepared a judgment and sent it to defendant and have not received any response as to how this judgment is different from the court's order at the end of trial. So I don't understand why she refuses to sign. I've had no contact with her about my proposed judgment.
All right, thank you. Ms. Blank, how is this proposed judgment different from what I determined at trial?
Yes, ma'am. I would like to correct. I received that decree on March 14th. By the end of business day, by March 15th, I did reply in an email because I had questions on section 4, which is photos and videos, and then the calculations at the very end of the decree, which had stated that $1,100 had already been paid to me for rent, and I didn't get a response. So I kind of chased my tail, tried to obtain transcripts, and was told that you can't unless it was requested at the beginning to request transcripts. So I just kind of went in circles, and then I seen the motion that they did file, and I just decided to go with it.
Well, why don't we take the issues one at a time? The photos, Ms. Ballast, do you understand what she's referring to?
I think she's talking about the intimate images provision.
Yes, ma'am. I'm sorry.
I've been including that in judgments as standard language. So essentially it's saying that if either party has saved an intimate image of the other person, they will delete it and not share with any other persons.
Okay.
So that wasn't part of my opinion, I don't think, but do you object to doing that, Ms. Blank?
Not at all. Not at all.
Great. And then let's move on to your next issue, the payment. Ms. Ballast?
Yeah, I did attach an exhibit to the judgment stating what Mr. Blank had been paid since the time that Ms. Blank had not been at the property. And she refers to an email that she sent me apparently March 14th. I do not have it. So
we're dealing with it now. So
okay, that's fine.
All right.
So my exhibit essentially outlined what Dustin had been paid and what would be paid back to Marisha as a result of the rent by the two other parties.
Okay, so it sounds like her issue is the line that indicates subtract $1,100 for 2 months. Marisha was paid already. She's nodding her head.
Yes,
okay.
ma'am.
So are you saying you weren't paid that, Ms. Blank?
I have not. I don't know where that amount came from. And if I did, I apologize, but I've gone through everything. I'm not sure what that amount is.
Okay, Ms. Bells, could you enlighten us?
I think that it would be better if my client could provide information about that because this was information I got directly from him.
Okay, Mr. Blank, can you tell us what that amount represents?
Well, it's kind of hard for me to do that without anything in front of me. I calculated everything. I don't know particularly what that was, but I know the calculations I had is what I received in full, and that was the amount. I don't know what we're referring to because I don't have any papers in front of me at the moment. And nobody told me that that was an issue prior to coming into here.
So Ms. Blank, you're saying that you were not paid?
No, ma'am.
Okay. I think given the situation, what I'll do is adjourn this, I'll adjourn it for 2 weeks.
Okay.
Ask Ms. Ballast if you would, and Mr. Blank, if you would provide whatever proof you have to your attorney. Ms. Ballast can provide it to Ms. Blank regarding that payment, and then hopefully resolve the issue, and hopefully Ms. Blank will be comfortable signing either the proposed judgment, or if it needs to be amended based on that information, that she'll be comfortable signing that. Otherwise, we'll have to come back.
Okay,
It's my exhibit A that we're talking about,
Got
so I'll make sure that we circulate it before that 2 weeks. Do you want me to renotice it, or will the court do that?
No, I'd ask that you do it. Hopefully it
Okay.
won't be necessary. Present in the virtual courtroom. We have both parties, as well as attorney John Shirley on behalf of the plaintiff, Timothy Young on behalf of the defendant, and Krista Benson, who my understanding is that plaintiff requested be present in case the court had any questions. I have read the motion and the response. Mr. Shirley, anything else you'd like to say at this time?
Your Honor, I don't know to what extent you know the history of the parties. I'd be happy to give you a brief summary if that would be helpful.
I think I have a pretty good handle on it. As
Okay.
I said, I read motion and response.
Great, thank you.
So you have nothing else you would like to add?
No, just that, my client is just concerned that this child really doesn't, know the defendant, and he had some unsupervised parenting time last summer and it did not fare well. And she's just happy to facilitate parenting time, but she thinks it should be supervised.
All right. Mr. Young.
Your Honor, I would take exception to that, frankly, and indicate that the parenting time did go well, unsupervised. No complaint was filed that I know of with the friend of the court or the court seeking to restrict any future parenting time, making it supervised. I would note, just in the court's order from August the 23rd of last year, the court did acknowledge, with her history in the case, that it was clear that the plaintiff had obstructed the relationship, or the continuing growth in the relationship between the child and his father. It's our simple request that he be given the 4 weeks in July, which is what the order contemplated. And I don't think there's any reason not to allow that to be ordered at this time. And that's what we're requesting. Thank you.
All right, thank you. Well, I don't see any reason at this point for supervised parenting time, so I'll deny that request. So the only issue then is the schedule. Mr. Shirley, I saw there was some question about the schedule. Has that been resolved?
No, the plan last summer was to wait until she received information relating to her fellowships and when she would be around and when she wouldn't. So the dates starting in late July and running through late August are the dates that will fit with her schedule. And I would request that the parenting time be fit in so that that schedule can be accommodated.
Mr. Young, you're muted.
I would simply refer the court to the order from the 23rd, in which the judge said, as the defendant has a job as a university professor, the time that he is available is the 4 weeks in July, as he is starting a new term, the early weeks of August. So I'm kind of not surprised that the schedule I'm getting is for August parenting time, knowing that my client cannot exercise that. We believe that the judge's contemplation of the 4 weeks in July as being the time that he would be granted that parenting time. The only question is really whether it's uninterrupted or whether it's, broken up. It's clear that apparently she is going to be in Kansas City for a period from July 8th to July 23rd. I think it would work out perfectly if my client were to pick up the child on July 1st and he can exercise the parenting time in Grand Rapids. And when she returns on the 23rd, the child would be able to be returned to her at that time. And that seems to be a perfect solution for the schedule, at least.
Mr. Shirley?
Your Honor, I know that my client believes that that would be an absolute detriment to the child's mental well-being. She maintains that this child really doesn't know him. He has 2 15-minute visits by Zoom a week, and after the unsupervised visits last summer, the child was having nightmares. I asked the court to I submitted a request for an in-camera interview with the child. I think that would be helpful. And I know that she's going to think that him having the child for 3 weeks unsupervised overnights is going to be extremely unhealthy for the child.
Mr. Young?
Yes, again, Your Honor, I have to go back to, again, the prior hearings that we've had, and I have not gotten the transcripts. I guess I probably could get those and make them available, but
The court is going to go by the order.
yes,
in the
so
case.
the concern that we have had, this child knows his father. The only concern about what happened last summer was mom's attempts to disparage the plaintiff in front of the child. And so when the child came to be with dad, he would repeat things that his mother said about him that were negative, that he was to be afraid of him, that he's dangerous, all these sorts of things that I think are coming from mom, which in my mind creates a really important opportunity this summer that he needs to be able to, I don't say counteract, but to at least develop a relationship so that those comments that mom is going to make, and I have no delusion that she's going to continue to make these comments on into the future and in coming years, he needs to be able to have an opportunity to get to know his son. Now, granted, last year he did not have overnights, but he had 4-5 hours of time. It was without incident. Now, we are simply proposing that the natural progression, he's a year older. They do talk every week, 2 times a week. That has been interrupted from time to time. That has not always gone well because mom has not always allowed that. But this is a child that needs to have a relationship with his father. The father is going to spend thousands of dollars to come to the States and stay here for the 4 weeks. And so I believe that we don't need to make this any harder for this child than we need to have it made. I have, for one, nightmares have never been mentioned in any conversation between the plaintiff and defendant. I have requested in interrogatories the information about what these nightmares are about. I don't believe they exist. I believe that the child may have a dream from time to time and maybe comes into his mother's bed, but it has no connection with the time that he spent with his father last summer. I believe that the mother's proposal that the father come thousands of miles from India to spend 29 total hours with his son over 4 weeks is simply indicative of the animus that she continues to have toward him. And we need to really try to put a stop to that. And the way to do that is to give Mr. Kamat his 4 weeks in the summer with his son.
Your Honor,
I just said, Mr. Shirley, I have a question for you. Is this child in counseling currently?
no.
Okay. And this child is how old?
5.
Okay. Given all of the allegations in this case, I think it's appropriate for this child to be in some counseling. I think it would be appropriate During the parenting time this summer, that father and child go to counseling together. I will grant father parenting time from July 1st to the 23rd. I expect this child to be enrolled in counseling, begin counseling individually before that. It may be play therapy, and I leave that up to the counselor that's chosen. And then whatever that counselor recommends in terms of therapy with father, that occurred during parenting time. But yes, this case needs to move forward. The relationship between the child and the father needs to grow, and everyone needs to support that and do what they can to support this child. Is there anything further? Yes.
Okay, so we're concerned, we're concerned about the fact that the defendant is not a U.S. citizen. He's here on a passport. We would, at the very least, request that he surrender his passport while he has the child. My client has concerns that he may have ideas of leaving the country with the child, and we want to make sure that that doesn't happen.
Mr. Young, are you willing to accept his passport and hold it while he's here to alleviate that concern?
Yeah, I guess I haven't talked to my client about that. He's not going anywhere. He's coming here for the 4 weeks and he's leaving. So to the extent that he doesn't need his passport and has other identification he can use, my concern would be if he's renting a car to get around town, that he may need some identification that is accepted. So I guess within the parameters of his being able to do what he needs to do while here, I don't have any problem with the passport being provided. I haven't consulted with him about that, but I suppose I could ask him that question now.
I have traveled internationally recently. I am just going to order that he turn that passport over before he begin his parenting time. So by that point, he needs to make arrangements so that he's rented a car. He's done all of the things that require identification, and then he will get it back in time to leave.
Okay.
Also, Your Honor, we don't have any idea where he intends to stay, what he intends to do, where he intends to go.
Okay, those details, he doesn't need to provide an hour-by-hour schedule, but he does need to provide the information to the mother regarding where he's staying, so where the child's going to be. Not an hour, even a day-by-day schedule, but if he's going to leave town with the child, where he's going, that just your basic information that any parent would need to know, but nothing in detail.
Very good.
Mr. Kamath, you do have an attorney, and so I won't allow you to speak at this time. All right, is there anything further?
Is that pickup would be at noon on the 1st? What would be the time of pickup?
Does noon work? Mr. Shirley?
Mrs. Swamp?
I would ask that the attorneys work out these details.
Okay. Thank
If
you,
you
Your
need a
Honor.
case conference with me, feel free to ask for one if you can't come to an agreement, but the broad parameters are there. And of course, some of it's going to depend on arrival, departure, those kinds of itinerary items that I know have not been finalized yet.
Thank you, Your Honor.
Both parties are present. Okay, we're adjourned. Thank you. Along with their respective attorneys, Mr. Lambert, on behalf of Mr. Almas and Ms. Selleck on behalf of Ms. Luna. We're here on the plaintiff's request for de novo review and objection to the interim order that was entered in this matter after evidentiary hearing before the court's referee. And I have read the motion. Mr. Lambert, is there anything else you would like to say?
Yes, Your Honor. Procedurally, my client was not represented during the evidentiary hearing to which he now seeks a de novo review of. We did order the transcript. I did subsequently meet with him to discuss the transcript. We made a.
And let me just say, I've read the transcript.
Okay.
So,
My client, still has issues, regarding the hearing, and that's the point of this de novo review. Essentially, one, the order does not reflect the requirement that she have consistency and full compliance with the parenting time in order to move on to the next phase. The order transcripts indicates that she has to be in full compliance on her weekend parenting time before she moves on to additional parenting time, and that's not contained in the order. That's the very least that should be in the order. My client has other concerns regarding housing. She rents a room. From a stranger, essentially, and my client has concerns on that. His biggest concern is that despite his testimony and despite Miss Luna's admission that she was convicted for use of drugs, that she's had a drug problem in the past, and we're happy to hear that she's allegedly clean now, my client has concerns that she has a lot of individuals hanging around her that are drug addicts, essentially. And he feels, and I kind of had some concerns also in this regard. The referee seemed to dismiss his concerns based on the fact that he did not know the names of any of these individuals that were addicts, in his opinion. And that's on page 37 of the transcript. Because he could not list the names, he seems to have been disregarded in that regard. But his concern is, look, if you're hanging around all these addicts, if you're hanging around individuals that clearly have drug problems and you have a history of drug problems, that's concerning. That's concerning to my client. And he feels that the order does not put any safeguards in place to make certain that she does not slip back into that behavior. And the first step in that is the fact that she's hanging around all of these drug addicts. With lack of stable housing, he feels that she needs to acquire more financial stability. Even though she does have a job, she indicates she has a job, but apparently it's not sufficient with regard to her housing. Otherwise, she would not be renting a room. That, in conjunction with the past drug addict issues, the drug conviction issues, and the people she's hanging around, leads him to be concerned that she might slip back into that behavior, selling drugs, associating with people with drugs, etc. And so that we need to put some safeguards in place. There is a concern regarding her.
Mr. Lambert, let me stop you just right there. What safeguards would you be satisfied with, or would your client be satisfied with?
Well, I have not thoroughly discussed that with them, but I think should, at the very least, we should have continued testing. We should have a restriction on associating with anyone that uses drugs. Illegal drugs, that is. I recognize marijuana is legal, although I wonder why the legislature did that. But nonetheless, we need to have these safeguards in place. Also, there's a problem with depression. We need medical compliance. We need to know that she's compliant with her meds, and that remains in place. There's no safeguards in that regard, despite the fact that she admits on page 17 that there is a history here of depression and that she suffers from it. There is another concern regarding her brother.
All right, let me stop you again.
Okay.
You said you need a safeguard. What would you recommend, or what would you be satisfied with for a safeguard?
With regard to the drugs,
the mental health,
depression, the mental health, we need compliance. We need to make certain that she's compliant with all meds.
I understand, but what is it that you want? A provision in the order that requires medication compliance? Is that what you're looking for?
Yes, we would like that, Your Honor. We would like that. We would like a requirement that if she suffers any, if she has to go in for any treatment, that she notifies my client within 24 hours. If she has to go in for additional treatment, or she has a relapse or anything like that, he would like to know that.
Okay.
The next issue we have here is the stepfather and the brother. stepfather is concerning. She acknowledges that this is a gentleman that has mental health issues to the extent that he exposes himself and has masturbated. Right. You read
And
the
again, I've
transcript.
read all of that. I don't need to, we don't need to rehash that for purposes of time, as well as it's rather unsavory.
So we would like a provision that he's not around the child, period. We don't want him around, period, even with Miss Luna present, because obviously he can't be controlled. With regard to the brother, we would like confirmation that he has moved. She indicated that he was in the process of moving, I believe, to Colorado. We would like indication, verification that he has moved so that he does not present as an issue. Those are the main concerns that my client had that he does not believe were appropriately addressed at the hearing, Your Honor.
Thank you. Ms. Selleck.
Yes, good morning, Your Honor. Can you hear me okay?
Yes, I can.
Yes, I know we are here regarding that plaintiff's request for a de novo review, which under MCL 552.507 and the court rule 3.215F lay out pretty clearly the requirements for a de novo review. Specifically that the court that this is that this is discretionary and that there are caveats to a de novo review request. And I have heard what Mr. Lambert has had to say. I would say that in light of the requirements for it, very loud on Division Avenue.
Okay.
In light of the above, I would say that both parties were given a full opportunity to present evidence at the referee's hearing. I have read the transcripts. I have reviewed the transcripts. It seems that the referee allowed each of them to make a narrative presentation and followed up with specific questions to make sure that answers regarding the established custodial environment, the child custody factors, and parenting time factors were all fully addressed, along with the concerns that each party had during that hearing. I had a chance to review the plaintiff's request for this de novo review, and there are no specific objections to the referee findings or facts or conclusions of law. He only states that the ruling is not in the child's best interest, and that, again, as Mr. Lambert has briefly said, a myriad of additional conditions imposed on Ms. Luna as she transitions from this 3 months of 3 weeks on 3 nights a week custodial time to alternating weeks of custodial time. I don't see, there has been no showing that any witnesses or exhibits were not available at the hearing date. And it sounds, again, it's our position that, that they're just not happy with the ruling, and we think it was completely and utterly fair. Specifically, given that the parties had a chance to present all of the evidence with the referee's assistance, I would add, from reviewing the transcript, I think that, with the lack of any specificity on the plaintiff's objection to either facts or law, I think that the court could issue an opinion based on the record. However, I'm very familiar with the case law that we've had recently, specifically the Butters case. So I think the waters are a bit muddied. So I would say that, if we would just ask that, maybe a 2-hour hearing on this subject may be necessary, but we would ask that, it be specified specifically what is Mr. Almas objecting to regarding this.
So the conditions that Mr. Lambert was asking for, you're objecting to the addition of those conditions?
At this point, yes, Your Honor. I feel that the referee's recommendation was more than fair, and I think that this is just another instance where there's trying to be, unnecessary restrictions put in place to prevent my client from being able to, follow the court's guidance and exercise parenting time. She has been clean for over 5 years, and any of the assumptions with the drug reference, I think, are very inappropriate. And I think, again, that both parties had substantial time during the referee's hearing to bring these concerns. This testimony was elicited out regarding these concerns, and the referee issued, in my opinion, a fair opinion.
Mr. Lambert?
Your Honor, my client's testimony is evidence, and he feels it was disregarded utterly. That he had concerns. Those concerns weren't appropriately addressed with regard to the drug use in particular, associating with known drug users, etc. And the main reason for that was because he couldn't give names. he can't give names because he doesn't associate with drug users.
All right, I'm gonna set, actually, I'm gonna set a 1 hour evidentiary hearing because I have read, the testimony or the transcript. So I don't want to go over all of that again. I, simply want to address, frankly, the requested conditions and the basis for those, that Mr. Lambert has requested. So we will just restrict it to that, and, hope that 1 hour is sufficient. And we will get you the date for that.
Thank you, Your Honor.
That the date not fall between, I am out of the country between May 21 and June 5. So if there's a date, obviously.
I don't have anything probably that soon, so I think you're
Excellent.
safe. So
All
something after June 5.
I'll prepare the order. It is 1 hour regarding the requested conditions. Is there a limit regarding new evidence and testimony, or is it just on the transcript, or what?
That's kind of what I said. It's just on the transcript, and then I will allow brief. It's limited, as I said, to the conditions that you're asking, which I understood to be continued testing, restriction with that association with any drug dealers, or drug users. I'm sorry. That mother remain med compliant, that she immediately notify father within 24 hours if she has any, I'm not sure what probably the best wording for, but essentially any mental health issues where she needs to, seek inpatient treatment or something like that. Essentially the same as if a parent had to go to a hospital for a physical problem. No contact with the stepfather whatsoever, and confirmation that the brother has moved. Those are the ones I wrote down. Was
Right.
that pretty much encapsulated?
Yes.
So
thank you, Your
that's
Honor.
what I'm limiting the evidentiary hearing to, are those items.
Excellent. Thank you.
Okay?
All right.
All
Have a
right.
nice day.
And if you hold off, Ms. Van, we're not gonna do it right this minute, but on that order, Ms. Van Noller can give you a date and time after she's consulted with both of you, and you can put that in the order.
Excellent. Thank you.
All right, 337 DC. Both parties are present in the virtual courtroom along with their respective attorneys. Let's see. Mr. Lambert, on behalf of Mr. Almas, Ms. Curry, on behalf of Ms. Luna. This matter was noticed out today for an evidentiary hearing regarding the objection to the plaintiff's objection and request for de novo hearing regarding the referee recommendation. It is my understanding that the parties have reached an agreement at least to a significant number of the issues, and who wishes to place that on the record?
Would you like me to, Mr. Lambert?
Go right ahead.
Okay, thank you, Judge. The agreement that the parties have reached is that Mr. Almos will withdraw his request for de novo review of referee Kessler's recommended order, and that order will remain in effect and final. And I would just indicate for the record that it was a phased in custodial time schedule, and the parties, because of the time that this took, already completed the first 3 months and are now in the week on, week off parenting time schedule and are exercising that. However, we've agreed that some additional provisions can be added by stipulation. I would be happy to draft that and send it over to Mr. Lambert. Those additional stipulations are that the minor child would have no unsupervised contact with, or be left alone with, or sit on the lap of Miss Luna's stepfather/father. The second one, that Miss Luna will comply with all health and medication requirements from her treating physicians. And the third one, that during either parent's custodial time, they will not allow the minor child to be in the presence of persons who are using any illegal drugs. And that's my understanding of their agreement.
Mr. Lambert?
That is the agreement. And that is a correct recitation of the agreement. there is another issue that my client would like to address that is outside of the agreement, but we would like to place that issue before the court, Your Honor.
All right. Do you need to inquire of your clients regarding the agreement before we proceed to the additional issue?
I think we should, Your Honor.
Okay.
Shall I go first?
Yes, you're plaintiff.
All right, thank you. Mr. Almas, can you hear me, sir? You have to unmute.
Yes, sir.
All right. Did you hear the agreement that was placed on the record, sir?
Yes,
Do you understand the agreement, sir?
yes,
And do you accept the agreement as stated on the record, sir?
yes,
And you had opportunity to discuss the terms of this agreement with me by email and phone over the last week or so, sir?
yes,
You understand that you could have gone to trial on these issues and the court might have ruled in your favor, might not have ruled in your favor on some or all of the issues.
yeah,
Are you entering into this agreement freely and voluntarily, sir?
yes,
Do you agree to be bound by the agreement, sir?
yes.
All right. Do you have any questions, sir?
No, other than just the rest of the thing.
Yeah, we're going to discuss the other unagreed portion as soon as we're done with locking in that which the parties agreed to, sir. Any
Okay.
other questions?
No,
No further questions, Your Honor. Thank you.
All right, Ms. Curry?
Thank you. Ms. Luna, did you hear the agreement that we placed on the record?
Yes, I did.
And do you agree to settle this matter according to those agreements?
Yes, I do.
And you understand that there will be a court order that adds the 3 other provisions that you agreed to the existing court order that had been signed by Judge McNabb previously?
Yes.
And you agree to be bound by these court orders, is that correct?
Yes. Yes, I do.
Thank you. I have nothing further, Your Honor.
All right, thank you. And I would like to congratulate the parties as well as counsel on coming to what I believe is a reasonable resolution of these issues. And Mr. Lambert, you wanted to address the issue?
Your Honor, my client's concern, he would like essentially a right of first refusal or input into who the child's babysitter will be. My client is available work-wise. He has very flexible schedule and he would like to participate in these things. He is aware that the court typically does not like entering these rights of first refusals. But under these circumstances, given some of the issues that were presented here, and also given his flexibility in his schedule and his availability, he believes it would be appropriate for the court to grant that, or at the very least, have the parties agree on who appropriate babysitters would be for the child, Your Honor.
Thank you. Ms. Curry?
Thank you, Your Honor. This right of first refusal is Mr. Almos's demand that he have the child whenever my client is working during her custodial weeks. I would first indicate, I don't think this really is properly before the court because it was not ruled on by the referee, nor has there been any request for additional testimony or for the court to consider this, but understanding that Mr. Lambert and his client would like a full resolution, I'm not opposed to the court considering the request. I agree with Mr. Lambert that rights of first refusal are not favored by the court for obvious reasons. There's no real statutory or court rule authorization for them. They create constant back and forth and interfere with parents' times, and they force repeated contacts between parents in high conflict cases like this one. And I would just also indicate, I know the court has read the record here, that Mr. Almos's request to have the child when she's working or to control who is the child care provider for my client is going to just perpetuate a pattern of controlling behaviors that referee Kessler noted in her opinion in multiple places. And so for that reason as well, I would ask the court to deny the request.
All right, thank you. As I think both counsel have indicated, rights of first refusal over the years have proven themselves to be more trouble than they're worth, frankly. And again, do place the parties in continuing conflictual situations where the parties, especially high conflict cases, are not likely to agree. And I think there's abundant case law that, in fact, I know there's abundant case law that indicates that whichever party has the custody of the child at the moment, it's their right to determine who provides care. Now, having said that, if there's an inappropriate person chosen to provide childcare, that certainly can be the basis for a modification in parenting time or custody. So I will put that warning out there. One would hope that a parent would choose appropriate people to provide childcare, but that does not always happen, and the court is aware of that. And I would say the best practice would be to consult with the other parent, if possible. But I am not going to order that at this time.
What about disclosures of the babysitters so that my client knows who she's picking and she should know who he's picking also, so that each party knows who the child is with, Your Honor?
Ms. Curry, do you have any objection to that?
I do. I just think it will continue a pattern here that we're just starting on. I mean, down the road, I hope there is better communication between the parties, but reading this record, I just don't want to put my client in that position. There's been abuse here and controlling behaviors, and I just don't think that's in the child's best interest.
Are the parties using Our Family Wizard?
I don't believe so, Your Honor.
Another app such as that?
I don't believe so, but
Right.
Your Honor, if I may, part of the problem here is Miss Luna's past and some of her questionable behavior with regard to the child. My client is simply trying to protect the child. I understand that there could be abuse, but likewise, there also could be negligent parental skills being exercised by Miss Luna with regard to the associations around the child and who she selects. My client wants to know who's watching the child, and he's willing to submit to the same by providing the same information to Miss Luna. I don't think that's unreasonable, particularly since the child is only 3 years old and not in a position to fend for himself, or otherwise call dad if there is a problem and say, hey, dad, this is what's going on. And likewise, the child can't call mom if there's a problem with dad and who dad selects. So I don't think that's unreasonable, Your Honor, at this point.
And I would just indicate that's not what we agreed to ask the court about. It was about a right of first refusal, nothing else.
Right. I'm going to deny that request at this time. As I said, as a simple courtesy, it would be nice if both parties exchange that information, and I would recommend Our Family Wizard or some other app that will allow safe communication between the parties. I mean, this isn't the only issue potentially that could come up regarding the child. And Our Family Wizard, there's a record of what's been said, what's been done. There's a calendar where you can put things on there that is important to the child. Mr. Almos, you're represented, so I'm not going to allow you to speak at this time. So I would recommend that both parties use that app for communications regarding the child. But no, I am not going to order either a right of first refusal or that the parties divulge who is providing care at this time.
Okay. Thank you, Your Honor.
Both parties are, thank you. I'm sorry, we're adjourned. The plaintiff is present along with her counsel, Mr. Haslam, and defendant is not present, but his attorney, Mr. McCarthy, is. We are here on the plaintiff's motion and notice of motion to quash third-party subpoenas. Just for the record, the court did conclude a trial in this matter. There was a subsequent motion and took the matter under advisement during the time that the court's opinion was pending. There was a motion regarding, well, let's just say it was a motion And after consultation with counsel, that motion either needed to be resolved or the court indicated that it would reopen proofs so that the parties could provide additional evidence or evidence regarding that pending motion at that time. In the meantime, and it appears the court, and after consultation with the attorneys, that in fact the court is going to reopen proofs. And that will mean that both parties have the opportunity to conduct discovery. I think 30 days is probably a good timeline for that. Is that sufficient?
Does that mean does that mean, Your Honor? I mean, I did raise here that discovery was closed, and I think they're clearly...
Yeah. The motion to quash is still. We're going to hear that, but I'm just indicating that if I'm reopening proofs, I would reopen discovery on a limited issue that we're talking about for both parties, and that's another reason I want to limit the time.
I would think 30 days would be. I would think 30 days would be sufficient, Your Honor.
I agree.
McCarthy. Okay. All right. Having said that, we will talk about the motion, which I've read. Mr. Haslam.
Well, again, first of all, I would be remiss if I didn't stand my ground. I suppose an unfortunate phraseology in today's lexicon of aphorisms, but discovery was closed. This is, albeit a minor collateral issue. It's an issue that I really think shouldn't be before the court, but for, as you saw in our previous motion, the defendant deciding to help himself to money that was not his. I know that counsel makes all these grandiose allegations that somehow my client lied in her deposition, et cetera, et cetera, et cetera. You have affidavits from the across the street neighbor. You have an affidavit from my client's stepfather. He gave her that money. I mean, honestly, I've never seen before a response to a motion where a party admits, one, he took the money, and two, he puts a picture of it in his response. Then we have a lengthy discussion with the court about, I think what the court suggested would be an appropriate way to resolve this. Mr. Dorn still has that money that he has expropriated, hasn't returned it to court. You see my communications to counsel. I don't hear one word from counsel in response to those requests. Then I start seeing a litany of vastly overbroad subpoenas asking for all manner of things dating back to January 1 of 2023. That's in relation to the neighbor. And as far as the stepfather is concerned, they're demanding his personal bank and financial account statements. Your Honor, there is no way that this meets and fits within the scope parameters of MCR 2.302B. This is not proportional to the needs of this case. The testimony you're going to hear from Mr. Dolfman is that, like a lot of old people, he keeps cash in his safe and has for years. He's paid the party's children to do yard work from that cash in that safe. For counsel to somehow create a construct here that unless there's a corresponding withdrawal from one of Mr. Dolfman's private accounts, then he's lying, is just a preposterous allegation. And there's absolutely no way that it is proper to send a subpoena to these people that reaches this kind of scope. Anything with respect to this ought to be limited to the day this happened. It shouldn't go back any farther than the date this trial was concluded, which is the date that Mr. Dorn went into my client's room, rifled through her things, and then took the money. This is an amazing, the defendant is turning this into an amazing wild goose chase and an amazing waste of time. from our perspective, Your Honor, let's just get a short time to have a hearing. The court can adjudicate the credibility of the witnesses that either side calls to testify. Honestly, Mr. Dorn's sole response, to paraphrase, for this motion or to our motion for the return of the money was everybody's lying except for him. And that is just a preposterous position to take, Your Honor. The other thing I want to raise to the court is I filed this motion citing various court rules and this court's order. And I indicated this, I think, in responding to Mr. McCarthy's statement that he wasn't going to file a response. He was just going to appear today. He was just going to appear today and argue a response. I think the court rules contemplate a response, and that is to avoid sandbagging, Your Honor. I don't have a response. As I indicated in my email, I think the court should treat that as a concurrence in my motion to quash. But if the court is going to allow these subpoenas to survive in any way beyond today, they need to be severely, severely limited in their scope and breadth, as I pointed out. And I think we're entitled to fees, given the vastly overbroad scope of those subpoenas, for having to file this motion and having to be here today.
Mr. McCarthy?
Can I share my screen, Your Honor?
Yes, I just want to caution, we are live streaming, so if there's anything personal in there, we don't want to share that.
Understood.
And again, I'm going to object because I had thought that defense counsel would do this, not file a response, but then want to carry us down the rabbit hole of let me share a screen, let me show the court this. That should have been done and should have been provided in a response, Your Honor. So I object. I would object.
I'm not obligated to file a response and spend more money on this. We've briefed this issue before, and I'm not going to show the court anything that's not already before the court.
All right. So it's something both the court and Mr. Haslam has seen before.
Correct.
Okay.
So I'm just showing you the testimony from the plaintiff's deposition taken on December 28, where I asked her, have you amassed an amount of cash? Are you holding cash? And her answer was like, what do you mean holding cash? A couple $100, 500? Do you think I have a stash? Is that what you're asking? Question, I'm asking whether you're holding cash. Answer, no, I do not have a stash of cash. Ask Steve, it's expensive to live a separate life. Question, so you don't have any cash? Her answer, no, I don't have any cash. That answer was false. And so we're going to open up proofs. I followed this up with a very direct subpoena to her father-in-law. Did the screen switch to you to the subpoena?
No. It's still Exhibit A.
Now is it showing you Exhibit A?
Yeah, it is.
All right. So I'm simply asking Mr. Dolfman to provide his banker account statements that depict the withdrawal of the $2,000 in cash. And if Mr. Haslam says, well, he doesn't have it, then that's what he can respond to the subpoena. And then I'm asking for communications that Mr. Dolfman has had with Laurel or with Mr. Haslam's office or with third parties with respect to the divorce. I've issued this twice because Mr. Dolfman refused, as did the neighbor, refused to pick up the certified copies of the subpoena. And so I've now had to get process servers to serve them. I've not heard back from whether the process server has served Mr. Dolfman yet, but the process server has served the neighbor, and the neighbor's subpoena is the same, with the exception of it doesn't ask for bank records. Are you seeing Aaron Wodarski's subpoena request?
Yes.
Okay. So that's simply, and that's referenced in the motion, all these supposed text messages. So I just want to get all of it, and I'm going back in time to get a context of them. And this goes to the issue in front of the court. I would ask that the court order that from the date that the subpoenas are served, that the subpoena be extended for 14 days, because you need 14 days from service. And I think we're just outside of 14 days or just inside 14 days on the Wodarski subpoena. Again, last I heard, I don't know that there's been service on Mr. Dolfman or whether he's trying to evade it or whatnot. But I would simply ask that the court, in its order here, deny the motion to quash. These are very direct, specific to get to the point of the issue in front of the court. And I would ask that the court, in its order, simply extend the compliance date to 14 days after service.
All right, thank you. I do believe that the subpoenas are, no.
May I respond? Your Honor?
No.
The sleight of hand,
No. I said no. I said no, Mark. Mr. Haslam, I said no, you can't respond. All right. I do believe that these subpoenas are too broad. I think they could be narrowed in order to get where what Mr. McCarthy is after. I don't think that asking a third party to turn over their bank account statements is appropriate, but I do think it could be reworded to indicate that he provide whatever proof that he has of that payment or payments, that he turned that over. That can be done in a number of ways, and I'm not going to get into how, but there's ways to do that, verified, so that he's not turning over his entire bank statement. As far as the text messages, I believe that also is overbroad. I think that needs to be narrowed to the time of when this alleged payment was made and 30 days either side of it.
You're talking specifically about the Dolfman subpoena, Your Honor?
Yes. I'm taking them one at a time.
Thank you. That helps.
We don't know when the payment was made. They say fall of 2023. And the other thing I think I'm entitled to find out, Your Honor, is if there was communications with him with respect to what the plaintiff was doing with cashing checks and walking around with cash, because we know for sure under the undisputed record that beginning in August of 2022, the plaintiff stopped depositing checks from the joint account into her own account. And she started to, and confirmed at her deposition, that from and after August of 22, which is when she decided to get divorced, she started to cash the checks at the teller counter and walk out of the bank with cash. So I do think I'm entitled to have a glimpse of any communications that were had with respect to either Mr. Dolfman or with the neighbor with respect to use of cash or whatnot. I think that's relevant and appropriate.
One, I think that's a misstatement of Mrs. Doran's testimony. She testified quite clearly she would use those checks to get cash for groceries and for some other things, which I believe included trying to use some marital funds as opposed to money that she had set aside. We
don't have to rehash the testimony. It is what it is, and I know what it. I mean, I was there. I took notes. So, again, I think this is just too broad. So, Mr. McCarthy, I guess I would ask for your help in terms of what you could live with in narrowing this down, because we are talking about a third party in this case.
Your Honor, how about I provide a new Exhibit A and I send it to Tyler, and if you can just confirm that, and then what I don't want to have to do is reissue or reserve these subpoenas. So can we find a way that I can deal with that without having to reserve? And I've got people who have avoided these, so I don't want to be put to the expense of doing that again.
That is an absolutely false statement, Your Honor. These people are not trying to avoid or evade service of process. I mean, the motion before the court is to quash the subpoenas. Mr. McCarthy now wants to do kind of a I wouldn't describe it perhaps as a backdoor process where he sends a different exhibit A, and then how is that supposed to be served on these third parties? And I think the court's proper observation here is that these are third parties with certain rights of privacy and the right to process.
All right, I think Mr. McCarthy, I think you're going to have to redo them. So
All right.
I will grant the
And I would
motion to
I would ask for
quash.
something just slightly longer than 30 days for discovery. I would ask for 45 days to give me time
Okay.
to make sure that I'm not going to have any problem getting them served and getting them.
I think that's appropriate, given my ruling.
Okay, so 30 days on either side. So we're on the Dolphman subpoena, 30 days on either side. And can the court respond to my request to include scope with regard to use of cash? Any communication with respect to cash?
Let's see, let me get back to your Exhibit A. Yes, I think if you limit it to use of cash, that would be appropriate, acceptable
Use of cash by the plaintiff.
by the plaintiff. Yes, I think that's what he's looking for.
Or obviously, or communications with respect to this advance, clearly. from
Yes,
Mr.
yes, yes, yes. I'm just trying to narrow it down so we're not talking about everything.
And as to the neighbor, the neighbor has, or the motion references a bunch of communications with the neighbor. And what I would like to do is to ask just for all of her texts to and from that neighbor from a 30-day window before this event. I think it was March, there's a date in the motion. I think it's March 8 or something like that. I'd like to go 30 days before that date until the date we filed the motion. Or date they filed the motion.
That sounds appropriate.
You said 30 days prior to March 8th?
And including the date the motion was filed, up to and including
Up
that
to and
date.
including the date the motion was filed. Okay. Regarding what?
All texts
subject
and all
matter?
emails, just everything within that window.
I think that's
Okay.
over. I
I will
think
do
that's
that.
overbroad, Your Honor. I think it needs, I think that should be limited to, I mean, this neighbor signed a sworn affidavit. I think it should be limited to those texts that touch on the subject matter of the affidavit.
I think that's appropriate. Because
Thank
I'm
you.
assuming that's what she's going to testify to or
But
about.
here's
Right.
my problem with that, Your Honor, is that now someone else is going to say, well, this doesn't relate to that and this does relate to it. That's what I want to avoid. I know that we have a relevant time period, and I just want everything within that relevant time period such that I know that what they're going to be producing is going to be responsive and compliant. When you say to them, well, you provide this that relates to this. Well, I don't think that relates to this. Well, let me be the judge of whether it relates to it. And the way to do that is to have a narrow time period and order everything, all of your communications over that time frame ought to be provided.
We're talking about what, about 6 weeks?
I think
Correct. Yeah, I mean, we're only talking.
I think we're talking about here, Your Honor, between between March 8th and the date I filed the motion, I think is about 2 weeks, if I'm not mistaken.
Oh, then I think that's
no, it's
fine.
30 days before March 8th until he filed the motion. So you're right. It's
I
about
would-
five, it's
I
about
don't-
5 or
I
6
don't
weeks, Your Honor.
I don't understand why it would be 30 days prior to March 8th, Your Honor. That's the day on which the event occurred. Right after the second day of trial.
Because I want to see the history of the communications and how it may relate to that.
All right, let's just do 14 days prior
Okay, thank you.
and then through the date the motion was filed.
That would be the 22nd.
Mr. Haslam, can you ask whether they would permit you to accept service for them?
No.
I'm
No,
sorry,
I'm
was
not-
the
no,
was the
I'm
answer
going
no?
to the court. I am not going to involve myself as a representative in any way for any witness, but thank you for asking.
All right. I think that takes care of everything, and then we'll Ms. Vadola will get with you guys to try to schedule a date.
So these 4 subpoenas are quashed, and council has to issue and serve new subpoenas within the scope of your ruling pursuant to 2.302 B, and you're reopening limited discovery for 45 days, limited to the facts raised in the motion for return of the money. Back to the plaintiff's request for attorney fees and costs associated with this motion. Obviously, the defendant filed these way overbroad subpoenas going back almost a year and a half, with the intent, we believe, under 2.302C, to oppress, harass, embarrass, and they're just inappropriate subpoenas, and you've quashed them.
I'm going to reserve on attorney fees.
All right, I'll include that.
You can certainly raise it again.
Both ways.
Yes.
Thank you.
All right. Okay, we're adjourned.
Thanks, Ron.
Present in the virtual
Have a good
courtroom,
Friday.
we have both parties along with their respective attorneys. Mr. Hess on behalf of the plaintiff, Mr. Crow on behalf of the defendant. We're here on actually both parties' objection to the referee recommendation and order in this matter. And I'll just tell the parties I spent significant amount of time reading all of the transcripts, reading the objections, the responses. So I don't want to rehash everything. If you just hit your highlights and your oral arguments, that would be appreciated. So, Mr. Hess.
Thank you, Your Honor. So for my objection to referee recommendation in order, as indicated, we do largely agree with it. The objection concerns how the parenting time is structured. There's some requests or there's some parenting time that's ordered for a weekend or even a day, and a fair amount of it, and that's just too much. I think both sides actually pointed this out, that there's that this places quite a burden on the parties and the kids with the travel and the exchanges. So we would request that the monthly weekends be cut down or eliminated. The holidays that are a day or so, let's see, Easter's 1 day, Mother's Day is 9 hours, and Juneteenth is 1 day. I mean, it doesn't really make a lot of sense to transport the kids across the country for a day or so. I mean, I understand the kids do need to see both parents, but I don't think that that's in the children's best interest, and it certainly places quite a burden on both sides with the transportation and expense. I would suggest that the defendant have a total of 4 weeks in the summer. I think that's appropriate considering all the circumstances. See, I think the exchange points need to be at the Grand Rapids airport up here, and the cell phone lot at the Pensacola airport in Florida. The defendant is able to give 3 weeks notice of her weekends. It doesn't specify how the transportation will be split. I'd suggest that each party is responsible for their own transportation when they're obtaining the child at the start of their own parenting time. That seems to make the most sense. There's already been some conflict about this. And as I've indicated, there was a big problem last weekend with the parenting time. My client's mother, who obviously lives here in town, was going to transport the children back to Florida, per the court order that is in effect. Defendant proceeded to cause all kinds of problems. I attached texts from her to my client, text between her and my client, text between her and my client's mother, a form that was signed during this 45-minute encounter with the police, where she claims to be bullied by having to follow the court order and give up the kids. So all of this is terribly unfortunate. She really seems to be overwhelmed with hostility and more concerned about creating drama and conflict than the best interest of the kids. Unfortunately, instead of the kids just simply being transported back to Florida Sunday night per the court order, they have to witness this huge 45-minute ordeal, the cops being involved. So I don't know, there's never been a court order that my client's mother cannot transport the kids or assist with transportation. This is their grandmother, not some stranger. This grandmother has always been highly involved in the children's lives. So the defendant's objections really don't make any sense at all. Kind of her militant approach with that really isn't in line with the a message that she sent to the school, which has been outlined in different pleadings recently, just highly inappropriate of what she sent to the school. Miss Jada Jones is also saying through the FaceTime parenting time, which she's been exercising since the interim effect order went into effect, she is saying highly inappropriate things, blaming, saying that she's filing a motion, telling the children that they're going to be going back to Michigan. I don't think that's appropriate to tell the kids that. And she's telling the kids to blame their mother, Haley, for different things. So, I mean, my client allowed that, but this is really problematic, and it just goes to the overall course of conduct of the defendant. I think that your March 27 ex parte order was entirely appropriate, which overruled the March 21 ex parte order. We went through a full trial on this, and we proved the custody, the change of domicile. We proved it in the best interest of the children. I think that the defendant in her recent pleadings is giving slanted and deceptive versions of what occurred. But I will leave that to you. One additional problem on Sunday night at 7:00, because the court order says that on Wednesdays and Sundays, when defendant does not have the children in her care, that she gets the FaceTime or video contact with her kids. So she had the kids last weekend, Friday evening to Sunday evening. Finally, the kids were turned over to my client's mother for the transportation back to Florida. And then she's contacting my client, trying to FaceTime the kids, claiming that that's been ordered. So that really doesn't make any sense. That's not what the interim order says. She did have the kids in her care that day, but that's how the defendant is interpreting it, that even when she has the kids from Friday evening to Sunday evening, she's still entitled to her FaceTime on Sundays at 7 p.m. So, of course, I've never heard of anything like that, where somebody has their weekend parenting time and then at 7:00, they have more FaceTime parenting time. So that's really unfortunate. Again, it's just adding to the overall turmoil quite unnecessarily. I think that the larger part of the referee's orders were quite appropriate, but the parenting time does need to be, the short trips need to be minimized quite a bit, if not entirely eliminated. Miss Jada Jones can have her 4 weeks in the summer. The court feels that's appropriate, and some other larger breaks. But that's our position, Your Honor. Thank you.
Great, thank you. Mr. Crow.
Thank you, Your Honor. So I would like to, if I could, just directly address the issue with why we are before the court today, dealing with the both the ex parte applications, Your Honor, and also dealing with the objection that we filed. I will say, and I do not intend to be hyperbolic at all when I say this, I have never seen a recommendation depart so profoundly from a record. And I am not going to, and the court has had the opportunity to review the transcript, so I'm not going to go into great detail at this time, although I would respectfully ask the court for an opportunity to do that at our hearing. I would say, Your Honor, that the conclusions that were reached by the referee in this case are based upon conjecture and based upon information either not in the record or that was impeached comprehensively on the record. And I would suggest to the court that there are a significant amount of mistaken or misappropriated facts that were used to come to the conclusion by the referee in this case. And I say that with great respect. In addition to that, there are new facts that have come to light since the time of the issuance of the order that are germane and relevant to the best interest factors. It is my understanding now that Ms. Jones is going to be moving into, I think, her 7th or 8th residence over the last 2 years. She is again taking the children out of school where they are the new school that they have been pulled out of the Grand Rapids school, the Michigan School District, and now they've been put into a whole nother school in Florida. Now they're being taken out of that school into another school because there's another move. This is the 7th or 8th move that the children have had. We filed an ex parte application, Your Honor, after the referee's recommendation was issued. The court granted that ex parte application, preventing the children from leaving the jurisdiction until the court had an opportunity to hear this objection. Then a second ex parte application, which I don't think was procedurally sound for there to be a second ex parte application. Quite frankly, what the appropriate procedural step would have been to file an objection to our ex parte, but a second one was filed, and that ex parte somehow, I think with a different judge, vacated our initial ex parte. So now we have a situation, Your Honor, pending the disposition of our objection. We have a situation where we have 2 children who have an attachment disorder and an avoidance disorder, in which the witness provided by Ms. Haley Jones in this case testified on the record that it was not in their interest to make immediate changes, which the record demonstrates. We now have a situation where we have these 2 children who have now been ripped from Michigan, who have now been sent to Florida in the middle of a school year, where they have IEPs already set up in Michigan and where there are not IEPs set up in Florida because of this decision. And we have children who are now being completely set apart from Ms. Jones and the relationship that they had with Ms. Jones. And this the need for the instantaneous moving of the children from one jurisdiction to the next while school is going on is not something I have ever seen, Your Honor, in these proceedings. There is absolutely no basis for doing so. And the court was quite correct to issue the initial ex parte so that the court could have an opportunity to hear our objections in the case. Let's be very clear, Your Honor. In the referee's report, there are facts and there are inferences made by the court that are not sustainable by the record. There are the witnesses provided by Ms. Jones in this case were considerably impeached during the cross-examination portion of this hearing, in so much that they went back upon their initial recommendations that they made. I can think of the counselor as one in this case. This recommendation, Your Honor, is far afield from what happened at trial. And I'm not going to argue balls and strikes at this time, Your Honor, as it relates to what happened at the trial. But there is no reasonable basis for this order to be issued. More to that point, Your Honor, with this recommendation being issued, we have 2 children who are now suffering irreparable harm because of this recommendation, because of the fact that they are, and I believe that the recommendation is reckless in its scope, in that we are taking 2 children who have a psychological disorder, and this is not my client's testimony. This is the testimony of Ms. Haley Jones's witness, who indicated.
Again, you're repeating yourself a little bit. I
don't
get
mean to,
that.
Judge.
So okay.
And so
let me ask you this. you said there's new evidence that has arisen. That was evidence that was not available at the referee hearing, correct?
So this is it. Correct, Judge.
Okay. And that specifically references a move?
Well, it at this point now, and there was testimony during the course of the hearing that Ms. Jones over the last 2 years, and Ms. Haley Jones, has moved somewhere, I believe, between 5 and 7 times over the last 2 years. Now the children, after this hurried relocation to Florida, now these 2 children were, I guess, supposed to go to one school district and go and live in one house. Now apparently there's another move afoot that the children in Florida are now going to go to another school district and have another home.
Okay,
So,
I don't want to argue the whole thing now.
Yes,
I
Judge.
just am trying to find where the parameters here, because the court is going to enforce the court rule. The court will set a hearing in this matter. The order remains in effect as it currently is in effect until the conclusion of the hearing, if in fact the court makes any changes. As I said, the court has read the transcript. The court is going to limit the review to those transcripts and on any evidence that was not available at the referee hearing yes, any evidence that was not available at the referee hearing the court will permit at this hearing. The court's not going to allow any evidence on findings of fact to which no objection was filed. And we'll find right now that the referee's finding was conclusive as to any facts to which no objection was filed. And we will let you know when that hearing is going to be. And
Yes,
as
Your
I said,
Honor.
it's going to be very narrow in scope.
So, Your Honor, just to clarify one point, if there are, and you'll forgive me if I'm putting too fine a point on it, but as it relates to the transcript and us being able to open that issue, we can certainly bring to the court's attention direct contradictions between what happened in the transcript and what happened in the recommendation. Is that also fair, Judge?
I would suggest that if you want to supplement your objection, that would be the place to do that.
Okay, Judge, but if it's already covered in the objection, that would be sufficient.
Yeah, sure.
Okay, thank you, Your Honor.
I'm essentially saying whatever's in the objection, the court will take notice of and consider. And if it's not in the objection, then it's conclusive.
Yes, Judge.
Okay. Any other questions?
No, Your Honor. Thank you.
So
Mr.
this
Hess?
is going to be a fairly limited evidentiary hearing? Is that where this
Yes,
is going?
the court is going to base the de novo on the record and the arguments that have already been submitted by both parties in writing, and any additional new evidence that was not available at the referee hearing is what the court is going to look at.
Okay.
Thank you, Judge.
Okay.
All
right.
In the meantime, there's no other changes to the current order. Is that?
Yes, it stays in place just as is.
So just to be clear, the court is, with the immediate relocation and the dueling ex parte applications, the court wishes the relocation to continue as it currently stands.
Yes. The current order of the court is the current order of the court.
Thank you, Your Honor.
All right. Thank you.
Thank you, Your Honor.
We're adjourned.